governance. Under rule of law, governmental authority can be legitimately exercised only in accordance with written, publicly disclosed laws adopted and enforced in accordance with the established procedure. It also enhances the rationality, intelligence, and legitimacy of decisions made by the governments. Rule of law holds particular significance to multicultural and multilingual societies like India. Without the rule of law as a limiting force, popular will can easily be corrupted by passions, emotions, and short-term irrationalities. Rule of law helps us to behave according to our long-term interests and reasons. Secondly, rule of law means equality before law. As Dicey said, not only that no man is above the law, but also every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Article 14 of our Constitution ensures equality of every person and ensures equal protection of laws within the territory of India. Third, rule of law means procedural and formal justice based on a complete set of decisional and procedural rules that are fair. Application of rule of law does not automatically ensure justness of the laws or effective delivery of justice. Rule of law is only concerned about how the legal system upholds the law. Therefore, at least in theory, it is possible for an undemocratic nation or one without respect for human rights to coexist with the rule of law. Therefore, the institutions of democracy must ensure that every citizen enjoys the fruits of the rule of law. Rule of law must not end up emphasizing too much on the law in the books. It must also emphasize on law in action. The essence of the rule of law lies in its substantive or functional outcomes. It must be driven by moral vision of a good legal system. The ultimate goal of rule of law must be the attainment of liberty, equality, and justice to one and all. With that note, I end my speech. Thank you.
And I welcome the Right Honourable the Lord Phillips of Worth Matravers, the Lord Chief Justice of England and Wales.
Your Excellency, the President of India, Chief Justice, distinguished colleagues, ladies and gentlemen, it is a great pleasure to be back in Delhi, albeit all too briefly, and particularly that my visit should be the occasion of having conferred on me an International Jurist Award. I enormously appreciate this honour, and although when I considered my citation, I had a little difficulty in recognising the recipient. On the occasion of my first visit to India, in the interest of justice, I could never have imagined that one day I would receive an award from the President of India. That visit took place in 1968, nearly 40 years ago. I was a young barrister practicing at the Admiralty Bar. I was junior counsel to Barry Sheen, QC, in an action that arose out of a collision on the River Hooghly. The pilotage authority in Calcutta had given permission for the pilot of our ship to come to London to give evidence, but refused permission for the pilot of our opponent's ship to come. And so the Admiralty Court had made an order that his evidence should be taken on commission in Calcutta. I was disappointed when Barry Sheen said he didn't think that the case justified having two counsel flying to Calcutta, and so he would be going without me. Our solicitor had formed the same view about two counsel, but decided to send me on my own. And thus it was that I arrived at Calcutta with instructions not only to cross-examine the pilot who'd not been allowed to come to England, but also to find out from the pilotage authority why he had been refused permission. The former task proved very much easier than the latter. I was passed from official to official until finally I found myself before the head of the pilotage authority. He explained that the authority had been very keen to assist the English Admiralty judge, and that was why they'd given permission for the pilot of our ship to travel to give evidence in England. They had refused permission to the other pilot out of apprehension that he might not tell the same story, which they thought would make it very difficult for the Admiralty judge to find out what had happened. Your Excellency, had the head of the pilotage authority obtained a degree of Bachelor of Laws, as you did, he would surely have heard of the principle audi alteram partem. On that visit, I formed a great affection for both India and its people, and I've been back many times, the first of which was when I introduced my wife to this country. By now, I was a QC, which proved to be just as well. My wife is French, and unknown to us, India had just introduced a visa requirement for French visitors. When they refused to let my wife in, I asked to see the chief immigration officer. He looked at my passport and asked, "What is this occupation, Queen's Counsel?" Well, I answered, "When Her Majesty has any legal problems." He was visibly impressed, and my wife was allowed in. And we went to walk up the Pindari Glacier. More recently, I've found myself visiting India in a judicial capacity over the last 10 years as a member of the Indo-British Legal Forum, where senior members of the British judiciary and legal profession have met with members of the Indian Supreme Court and other distinguished Indian lawyers. In the course of my visits, I've made many good friends, some of whom are here today, and I was particularly looking forward to sharing the honor of being a special guest with my good friend, the Union Minister for Law and Justice, Dr. Bhadwaj. But unfortunately, I've learnt that he has fallen ill with a viral infection, and I'm sure we all wish him a speedy recovery. In my country, we have great respect for Indian law and Indian lawyers. In particular, we hold the Supreme Court in very high regard indeed for the erudition of its jurisprudence, for its devotion to the rule of law and to the human rights and welfare of the Indian people. We live in troubled times, and one only has to look beyond the boundaries of this country to see judicial independence and the rule of law under grave threat. In fact, we do not need to look beyond the boundaries when we read with dismay and sympathy of the terrorist bombings of the courts of Varanasi, Lucknow, and Faizabad that occurred yesterday. Faced with atrocities such as these, some suggest that the rule of law must give way in the interest of national safety. I believe that it's at times like this that the rule of law is most important. Terrorism poses a challenge to our security forces, but the extremism that foments terrorism poses a more important challenge to our democratic principles, and that is not a challenge that we can win by force of arms. We can only win it by sticking to those principles and demonstrating their superiority. Both of our countries are facing similar problems in the face of extremism. I believe that we have much to learn from each other. We British certainly have much to learn from India, and I shall have plenty of opportunity to learn at today's conference. In the course of today, there will be no less than 20 working sessions. I am committed to the first one, Human Rights in the 21st Century. But after that, I am going to have the greatest difficulty in choosing between a variety of topics of great interest. It's not right that I should delay the proceedings any longer. Thank you for the great honor that you have conferred on me.
Thank you very much. I'm sure the numbers attending the Human Rights Working Session will be large indeed. May I welcome now Mr. Justice K.G. Balakrishnan, the Chief Justice of India.
Our esteemed President, Her Excellency, Srimati Pratibha Devi Singh Patil, Dr. A.S. Anand, former Chief Justice of India, Right Honourable Phillips, Chief Justice of England and Wales, my esteemed Brother Justice Tashiom, Honourable Justice Dr. Sharma, the Chief Justice of Delhi High Court, Mr. Milan K. Banerjee, the Attorney General for India, judges from the various high courts, distinguished guests who adorn the dais, distinguished delegates who have come to attend this seminar, students and ladies and gentlemen. I am happy that the legal fraternity is taking keen interest in the development of law by arranging seminars and conferences quite frequently at various places in this country. I think one more international seminar is going on in the very city of Delhi at some other place. The maintenance of rule of law, the access to justice, and judicial independence all have become common words for the common man. And the role played by the lawyers in spreading these basic messages is commendable. India is a large country with a huge population. Our problems are complex, and it is difficult to find any easy solution for all the problems that ail the society. We have got a fine constitution, and our democracy survived all threats and perils. Many of the countries which were under the colonial rule became independent after the Second World War. Though these countries initially started with democracy, but the system failed and the democratic form withered away and gradually crept into military rule or other forms of rule which is not purely democratic or representative in character. Our Constitution guarantees fundamental rights to every citizen. The citizens are also given the rights to enforce these rights. The fundamental rights enshrined in Article 14, 15, 16 and 17 reflect the right to equality in its various aspects and aim to foster social equality by empowering the citizens to be free from any form of coercion or restriction by the state or private people. The directive principles aim at creating an egalitarian society whose citizens are free from the abject physical condition that had hitherto prevented them from fulfilling their best selves. They are the creative part of the Constitution and fundamental to the governance of the country. The directive principles of state policy enumerated in our Constitution have been given prime importance, and many of those rights are brought on par with the fundamental rights. The preamble of our Constitution also proclaims that we should have justice, liberty and equality. We also gave emphasis to the fraternity, assuring the dignity of the individual and the unity and integrity of the nation. The basic question is how far these rights of the citizens are protected. For the principle of maintenance of rule of law, we mean that these valuable rights are protected under the help and guidance of our judicial system and law enforcing system. If we fail to fulfill the ambition and dream of the common man to achieve these basic rights, there is failure of the rule of law. It is not merely the protection of the person or the property of the citizens. The core of the rule of law is an autonomous legal order. Dicey, in his famous treatise, Introduction to the Study of the Law of Constitution, said, I quote, "The absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, equality before law or the equal subjection of all classes to the ordinary law of the land administered by the ordinary courts. The law of the Constitution is a consequence of the rights of individuals as defined and enforced by the courts." Unquote. Therefore, indeed, the judiciary is endowed with the responsibility of safeguarding the rule of law, but the judicial system as such is not confined to judges or courts. The enforcement law is not solely within the influence of the courts. Our police system, prison administration, the administration law, and order of the country all play a vital role in protecting the rule of law. Apart from justice administered by the courts, there is the wider question of political justice. The essence of political justice is that the government of the country is democratic, that is to say, that